everybody. We're going to go ahead and get started. And that way we have plenty of time to have the discussion and talk about waters of the United States, otherwise known as WOTUS. My name is Rob Verchick. I'm a law professor at Loyola University New Orleans, where I direct the Center for Environmental Law. I'm also a fellow at Tulane's very own Disaster Resilience Academy, the DERLA, Disaster Resilience Leadership Academy. And before that, or actually sort of in the middle of all of that somewhere, I was a political appointee at the EPA in the beginning of the Obama administration. And I mentioned that because one of the things that I actually worked on was trying to figure out what the heck waters of the United States actually meant. And there are a lot of different opinions. You might think that people would know by this time what water is, but it's hard. Now, I know that I grew up in Nevada, right, where I learned very early in life that there was water even when you couldn't see it, which meant when you went to camp out and hike in deserts, you never ever, right, pitch your tent in a depressed area, because you could wake up in the middle of the night and be underwater, right? Because in many places, at least in certain places like Nevada and so on, water that comes and goes, it evaporates, it comes back seasonally, and those sorts of things. And we have wetlands the same way. Sometimes they're dry, sometimes they're wet, in the interior of the United States. And so there are lots of definitions about what actual water is and what a water of the United States might be. Why do we care about that? Because there's a federal law called the Clean Water Act, which is responsible for giving the federal government authority over controlling pollution in a water of the United States, or it gives the Army Corps control over deciding whether to allow development or filling in a water of the United States. And so if it's a water of the United States, you've got the federal agencies involved and some protection at the federal level. And a lot of grief on the part of people who might want the states to control it or other owners to control it. And so that's what the issue is. Now, in 2006, way back, the U.S. Supreme Court tried to define what waters of the United States means. They tried it many times. They tried it then in a 4-1-4 decision. And it was very hard for anybody to figure out what that decision meant. So when the EPA finally decided to issue a regulation, a rule, defining what waters of the United States was, according to that 4-1-4 opinion, they got all mixed up too. And they actually issued a rule just last year which attempts to define that so that companies and agencies and owners know what that means. But as we'll find out, there's still a lot of play in the joints, and there are still a lot of people who disagree. There have been 3 federal court decisions now chiming in on whether what EPA did was correct or not. There may be more. To complicate matters, we now have a Supreme Court without Justice Scalia, who recently passed away. So that 4-1-4 division is now a 4-1-3 division. And what would a court do, a Supreme Court, with that makeup if it were to get some kind of an appeal from a circuit? Or what will it do when the new appointee, whoever that is, finally becomes a member of the Supreme Court? These are all the issues we're going to try to suss out today. So let me just tell you, we've got 2 wonderful speakers who have great experience in this area, coming from different points of view, which is going to be wonderful for us. And we're going to have them give us some slides and talk a little bit, and then they're going to give us a chance to ask questions and to push back a little bit if we want. The first speaker is Joe Della Penna from Villanova University. He's a law professor who teaches in the environmental area. He has been teaching in law schools in the United States and abroad for 47 years. He teaches environmental law, admiralty, Chinese law, international trade law, but especially from our point of view, we're interested in his teaching on managing water in the environment. In '95, he was the director of the Model Water Code Project of the American Society of Civil Engineers. In '97 through 2004, he was the rapporteur of the Water Resources Committee of International Law Association, and in that regard, he helped modernize the Helsinki Rules, which are a basic document of international water law. He has degrees from University of Michigan, Detroit College of Law, George Washington University, Columbia University. He knows water, all right? So he's going to help us out at least with one version of what that definition might look like for our purposes. Our next speaker is Christopher Pugsley, a partner at Thompson & Pugsley, counsel for the National Mining Association, an organization that also cares an awful lot about the definition of water. He focuses his legal and political practice on environmental and energy issues. Many of his issues in practice involve drafting, implementing legislation, and so on. His environmental practice consists mainly of statutory and regulatory analyses, development of new policies, and the conduct of administrative litigation regarding the Nuclear Regulatory Commission, the Environmental Protection Agency, and the state-based issues related to the possession and use of radiological and hazardous materials. He's done a lot of work, as I said, with the National Mining Association, the Food Irradiation Processing Alliance, and the Gamma Industry Processing Alliance as well. He has his degrees from Washington Lee University and his law degree from the George Washington University School of Law, and he's licensed to practice in Maryland and before the 10th Circuit. So what I will do is I'll simply introduce one and then the other, and after that we'll see if we have a little give and take going on. So Joe, please come on up.
All right. One of my characteristics, if you will, in my work, whether it's teaching, writing, lawyering, is always try to place things in the broader context. I'm more interested in the forest than the trees. Unfortunately, when you get a lot of cases on a particular issue, for example, what does Waters of the United States under the Clean Water Act mean? Tendency of lawyers and judges and scholars is to look only at those cases and lose sight of the broader picture. And so what I'm going to do is start more fundamentally, going all the way back to 1801, really. What did waters of the United States mean then, or navigable waters of the United States? What does it mean today? Trying to suggest that if you put it in this broader picture, you might get a very different reading of what Congress was trying to do in 1972 when it defined, or perhaps redefined, waters, navigable waters in the Clean Water Act. And, well, hopefully all of this will make sense. By the way, I do love that end of the storm drain, right? Are those navigable waters in the United States, or is that just a storm drain, right? All right. The relevant statutory text is quite short. And perhaps because it's so terse, it doesn't tell you a lot. The term navigable waters means waters of the United States, including the territorial seas. That's the whole statutory definition. And the question, it's come up to the Supreme Court of the United States 4 times, I think. And it's come up to, in lower courts, innumerable times. What does that phrase, navigable waters, mean in the Clean Water Act? Why is it important? Well, effluent limitations. That's one of the basic tools of the Clean Water Act. Limit the amount of effluent or discharge, if you will, that can be introduced into navigable waters. You'll see this, well, let me use this. You see, it doesn't say waters or waters of the United States. It says introduced into navigable waters. And also, the term discharge of a pollutant means any addition of any pollutant to navigable waters. And of course, both of those refer back to this very simple statutory definition. What are navigable waters in the context of the Clean Water Act? And since it's defined as waters of the United States, I put it in terms of what are waters of the United States in the context of the Clean Water Act. Now, it's a puzzle. You'll notice the missing piece is full of water, right? Back to the beginning. You know, it's originalists who argue that we should be only read the Constitution as it was originally intended to be read, or as its public meaning would have been understood at the time it was written, they ignore one very simple fact. The Constitution was written by the Federalists. The dominant reading of the Constitution that we now attribute to the founders of this country is the anti-Federalist reading, not the Federalist reading. That was brought into play when Jefferson won the 1800 election, and the anti-Federalists then called themselves Republicans. Later, that party came to be called the Democrats. And so historians, not wanting to confuse you, call it the Democratic Republicans, right? But it was actually called the Republicans. They came into power, and their agenda was to strip the federal government of its ability to do things. And I won't go into the debate, the historical debate about why that was their agenda, but it was. And so what we take, they were so successful. You compare decisions of the Supreme Court, and there weren't very many, between 1789 and 1801, or even actually around 1806 or 7 when the Republicans finally got a majority in the court, and those after the Republicans got the majority, the decisions often are very different. Between those who were willing to accept the federal government as a federal government that has the power to do things, and those who wanted essentially to strip the federal government of its ability to do things. And so the orthodox interpretation of the role of John Marshall, the great Chief Justice, is this great innovator who twisted the Constitution out of shape to make it possible to do things for the federal government, using necessary proper clause and other clauses. Perhaps a better reading would be the last diehard Federalist who was defending the original meaning. Now, what does that mean for us? Once the anti-Federalists got control, some of this might, by the way, resonate in today's political climate. They insisted all delegated powers, remember that shopping list in Article 1 of the Constitution, the powers of Congress, and Article 2 for the powers of the President, should be given their narrowest possible reading. I doubt that Federalists would have agreed with that. Certainly John Marshall didn't agree with that. But it had the effect of stripping a great deal of potential power from the government. In particular, they were worried about the Commerce Clause. It says the federal Congress can regulate interstate. It doesn't say interstate, by the way. The word interstate commerce does not appear in the phrase does not appear in the Constitution. What it says in the Constitution is commerce among the states and with foreign nations and with the Indian tribes. This was interpreted, and one of the key transitions the Anti-Federalists made in Supreme Court opinions was to substitute the phrase interstate commerce for the phrase commerce among the states. I don't have time to elaborate what difference that made, but it gave rise to the view, dominant from the early 19th century until the political and legal revolution of 1937 on the Supreme Court, that in order for Commerce Clause power to come into play, the actual activity had to cross state or national lines, interstate or foreign commerce. The activity took place entirely within a state. Congress couldn't regulate it. And of course there are some people, Clarence Thomas one of them, who want to argue that that's still the correct reading of the Commerce Clause. But the epitome of that is Federal League versus the National League. Again, if you're a baseball fan and if you really like the history of professional baseball, you'll know that in 1914 and 15 there was a third major league in operation called the Federal League. That essentially was driven to bankruptcy by the two established leagues, American League, National League. And so after they went out of business as an operating baseball league, the people who invested in the Federal League sued, claiming antitrust violation. All right? Does the Sherman Antitrust Act, it's a conspiracy to drive them out of business, does the Sherman Antitrust Act cover the business, if you will, of professional baseball? A famous opinion by Justice Oliver Wendell Holmes said, no, of course not. Baseball games are played within a single state. Therefore, it's not interstate commerce. Now, completely ignoring the fact that the National League, the American League, the Federal League all operated across state lines as leagues, I mean, that's sort of the epitome of this idea. It has to take place in more than one, the activity itself has to take place in more than one state, or it's not subject to congressional regulation. And it's because of that rather bizarre, I think, decision, which has been reaffirmed by the Supreme Court several times since 1922, that baseball is exempt from the antitrust laws, although the other professional sports are not. Interesting, because by the time they were sued for antitrust violations, we'd passed 1937. You had a different reading of the Commerce Clause. On the other hand, even the Anti-Federalists realized in a resource-rich but capital-poor country, often the only way you could raise capital to make what were then called internal improvements, roads, canals, dams, etc., was for the federal government to do it. And so the problem becomes, how do you find a constitutional basis for internal improvements without undoing what the Republicans of that time thought was their great achievement? That is, restricting the Commerce Clause in particular and federal government in general to its narrowest possible range of powers. As there's nothing in the shopping list of congressional authority that says you can build roads or dams or bridges, or, on and on. So comes a series of inferences built upon inferences. While they do have some ability to regulate long-distance commerce. Now think about it in 1810, 1820, before the railroad was invented, for example. What is the almost only way you do long-distance commerce? It's by boat or ship on water. And so, is there some way you can say that by regulating activities on water, you're within the scope of the Commerce Clause, and yet without blowing the Commerce Clause up beyond what they were willing to tolerate? The answer, and it was the courts that came up with this, they inferred from the Commerce Clause a power to regulate and promote navigation. This came to be called the navigation power. Now, of course, the word navigation does not appear in the Constitution either. It's an inference derived supposedly from the Commerce Clause. Congress, and therefore the federal government, has the ability to regulate navigable waters. Initially they said to promote navigation, later cases said destroying navigation counts too, as long as you can say somehow it's linked to navigable waters. If you go back and read the cases in the 19th and early 20th century, the navigation power became the leading power of the federal government for doing anything inside the United States. Recited in all kinds of statutes as the basis of the statute, when on the face of it, the statute had little or nothing to do with navigation. And that's where we get this obsession with the phrase navigable waters. All right. What then counts as navigation? Is this navigation? This is a log, a group of logs, being floated from where they were cut down to where they're going to be milled. Again, this antedates railroads or trucks. If you go in an area where there's active logging today, it's mostly trucks that carry the logs around, but in the old days it was all by floating logs. And this became such an important aspect of actual commerce that many states and the federal government said if it will float a log, not a group of logs, it's navigable. This is the floating log test. Now, the earliest definition, this was inherited from England, and we find it explicitly endorsed in Payroll versus Howard, is navigable waters means water subject to the ebb and flow of the tide. Now in England, that was a perfectly serviceable definition, because England's a relatively small island, short rivers, and very few, if any, rivers that are particularly useful for commerce that are beyond the ebb and flow of the tide. But of course, in the United States, that's not true. I mean, there are vast internal rivers, including the Mississippi, through most of its length, which does not see the influence of the tide. In 1845, the Supreme Court extended the concept of navigable waters to all inland waters useful, and this is the way they defined it, for interstate or foreign commerce. This is Fretz versus Bull in 1851. This was based on a statute enacted in 1845, I should say. The actual decision upholding constitutionality of the statute. Matter of fact, what the Supreme Court decided in 1851 is they didn't need the statute to extend the idea of navigable waters. That in fact, navigable waters always meant this. Therefore, the statute became superfluous. So it's still on the books. Still, question of what does that mean? Useful for interstate or foreign commerce. Daniel Ball, 1870. The Supreme Court said all waters that are navigable in fact. It becomes a question of fact, whether water could be used for navigation. And then in 1940, now this is the height of the New Deal and all of that, United States versus Appalachian Electric Power, litigation over the New River in West Virginia, which has cataracts and rapids and all kinds of things that would interrupt navigation. Is it navigable waters in the United States, therefore subject to what was then called the FPC, Federal Power Commission licensing requirement? Today that would be called FERC, F-E-R-C, Federal Energy Regulatory Commission. Supreme Court said, yeah, sure, as long as it could be made susceptible to commercial use with, quote unquote, reasonable improvements. Boom Company versus Patterson, U.S. Supreme Court back in 1878 had said floating logs is commerce. And finally, this is my favorite definition of navigable water. Simon Rifkin, who was the special master, one of the special masters anyway, in Arizona against California, a famous water law, interstate water law dispute, quipped when a lawyer was trying to argue with him that Colorado River, because it's such an arid region and so on, was not really navigable, and he quipped, if it'll float a Supreme Court opinion, it's navigable. And if you take that as a definition, there's very little water that is not navigable. The only question is it navigable in interstate or foreign commerce, or commerce with the Indian tribes, as the Constitution says. Up to this point, you'll know, if you were to go back and read those cases, you'll notice some are in admiralty, some are regulatory authority. You could also find title cases. The concept of navigability was, navigable waters were used in a variety of different contexts, and it was, the definitions from these different cases were treated as interchangeable. Right? You can use any of these cases to argue, which meant, of course, as Simon Rifkin's comment about flow to Supreme Court opinion tells you, the concept tended to expand to the maximum need in any context. That became the test for every context. Now, this is Hawaii Kai, which is a resort, second home kind of resort in Honolulu, just down the coast from Diamond Head, Waikiki. One of the things you'll notice is you've got a lagoon here, which was a big selling point when they're selling these condos to rich people who want to have a condo in Hawaii Kai. The idea is, here's your very own lagoon. We'll keep all the riffraff out. Nobody will get in here unless we allow them in. Well, you know, there are people who operate tour boats. Take a tour boat, go around and see Waikiki from the water side. And they wanted not only to go along the outside of the lagoon, they wanted to go in the lagoon, let their tourists get up close, take some pictures of the rich people in Hawaii Kai. And so Kaiser Aetna, which was the company that developed Hawaii Kai, sued, saying, If you do, if the federal government, and it was the federal government said you can go in, the Coast Guard to be precise, wants to do this, they've got to compensate us. They've taken our property. This became the issue. It reached the Supreme Court in 1976. Kaiser Aetna versus United States, 1979. And what they did for the first time, there had been some stuff in the law reviews on this, but first time in any court, Supreme Court announced that there's not one concept of navigability, there's four. Depending on the purpose for which you're using the concept. And they found that the lagoon was, well, think about it. If you just say flat out, it's not navigable, that means, among other things, Coast Guard can't apply the navigation rules of the road there. Right? No one wanted to say that. Do you pass to the right? Do you pass to the left? There are rules on that. And it's important that people follow the rules because the other people in the other boats are going to be navigating in anticipation that you will follow the rules. No one wants to say it's not navigable for purposes of the regulation of navigation. But does that therefore mean that there's no private property at all and Kaiser cannot claim compensation? Well, the majority of the Supreme Court said no, they can get compensation. It's not navigable for those purposes. So here are the four purposes. Defining title of submerged lands. Lands that are underwater. Generally speaking, there are exceptions, but generally speaking belong to the state in which the lands are found, in trust for the public. Okay? And so, but only if the waters aren't navigable. And so the question becomes, does navigation for purposes of navigable waters for purposes of title to submerged lands, does that mean the same thing when you're talking about regulatory authority or admiralty jurisdiction? And a second purpose for which you use navigable waters is to define whether the waters are subject to admiralty jurisdiction. They're navigable waters of the United States. Must be useful in interstate or foreign commerce. Lake Tahoe, for example, which is a flooded, extinct, well, we hope it's extinct anyway, volcano crater, right? It's navigable waters of the United States. In other words, because of its nature as a flooded volcano crater, water goes into the lake but not out. There's no water-borne connection between Lake Tahoe and any other body of water. But it's navigable waters of the United States because it's bisected by the California-Nevada boundary. So you could go by boat from one state to the other, interstate commerce. Crater Lake in Oregon, another flooded, extinct volcano. But it's entirely within Oregon. So whatever you do with a boat, you're not going to another state or a foreign country or even an Indian tribe. Therefore, it's not navigable waters of the United States. Substantially the same body of water. And one of the places where that becomes very important is admiralty jurisdiction. If there's a boating accident, for example, in Lake Tahoe, you can go into federal court, claim admiralty jurisdiction, but in Crater Lake, you cannot. Now, defining the scope of the navigation servitude. Even though you may have title to the submerged lands, whether the title holder is the state or a private property owner, if it's navigable waters of the United States, you're subject to a servitude. In other words, an easement in favor of the federal government. The federal government can exercise that easement with regard to the waters and the submerged lands, but not what's called fast land. Fast land here means not land that moves quickly, but land that never moves at all. Right? Therefore, they can take what you think of your property interests and not have to pay you compensation, because they're simply exercising the federal property right, the navigation servitude. Again, depends on whether we have navigable waters. And I've already mentioned with regard to the Coast Guard, but this is, of course, relevant for the Clean Water Act and many other statutes, the regulatory authority of the United States. Now, before 1979, whatever was the broadest definition of navigability you could find for any of these purposes, you'd apply to all. After 1979, after Kaiser Aetna, the court said, no, there are four different purposes, four different tests of navigability. The thing is, I didn't tell you what the four tests were, and the lower courts have to some extent split over what the four tests are. And of course, this last point, regulatory authority, becomes the focal point of the litigation under the Clean Water Act. Now, ducks in a pond, a marsh, whatever, is that navigable waters of the United States? For purposes of the regulatory authority of the United States, it might be navigable waters, might or might not. For some other purpose, is it navigable waters for the purposes of the regulatory authority of the United States? Well, does the term navigable waters limit the phrase waters of the United States under the Clean Water Act, or vice versa? Now, I'm going to pause for a moment, go all the way back, take a look at what the statute says. Let's get up here. Just this first one. Navigable waters means waters of the United States. Would seem that, just based on the semantics of the statute, waters of the United States defines what navigable waters mean, not the other way around. All right? Yeah. And so I asked that question because, as you'll see, the Supreme Court, at least 4 justices of the Supreme Court, wanted to argue exactly the opposite. That the phrase navigable waters limits what waters of the United States means. The first decision, United States versus Riverside Bayview Homes in 1985, held that the regulatory authority of the United States extends to adjacent wetlands. That is, unequivocally navigable waters. If you have wetlands, a swamp, a marsh, whatever other thing you want to call a wetland, adjacent to the unequivocally navigable waters is included within the regulatory authority under the Clean Water Act, even if the flooding is rare or non-existent. That's what the Supreme Court said in 1985. So if you go back and look at those ducks in that marsh, under the Riverside Bayview Homes case, almost certainly it's waters of the United States and therefore navigable waters. The Supreme Court also said, at least the majority in 1985, that the intent of Congress in defining navigable waters as waters of the United States was to repudiate. And this was said explicitly, not in inference. Was to repudiate traditional limits on navigability, to extend the regulatory authority of the Clean Water Act to the maximum consistent with the Constitution. And remember, this is at the heyday of the Commerce Clause as almost unlimited jurisdiction. The maximum probably means no limit at all. All right? 16 years later, Solid Waste Agency of Northern Cook County versus U.S. Army Corps of Engineers, 2001. You have a quarry, an abandoned quarry in northern Illinois that has been flooded by rains and maybe groundwater over the years, and it's kind of like an artificial lake. Now, the nature of a quarry is it doesn't have a surface connection, almost by definition. I mean, you can imagine an abandoned quarry where a stream somehow cut into it, but in general, it has no surface connection with any other body of water. It's a Lake Tahoe or Crater Lake of, artificially. Is that waters of the United States? And here, for the first time, 29 years after the statute was enacted, 16 years after Riverside Bayview Homes, the majority said the navigable limits regulatory authority. The word navigable limits regulatory authority in the Clean Water Act. Not the other way around. And it said it does not reach isolated wetlands. Does not reach duck ponds in a farmer's field in North Dakota. That's the classic example. But also didn't reach a quarry, an abandoned quarry that had become sort of an artificial lake in northern Illinois. There's still a lot of other gray areas, you might call them, that they haven't decided yet. Well, this comes up with Rapanos. and its progeny. Rapanos was decided 5 years later, 2006. This is the 414 that Robert Chick was talking about. Badly fractured, it was 3114. It's even worse. All right? The plurality, the three justices. We customarily say the plurality is the largest group of justices in the majority. The actual plurality, of course, is the four dissenters. The largest group of justices by number. That's what plurality means. But the plurality, meaning the three, held and insisted somehow that they weren't contradicting Riverside Bayview Homes, which I think very manifestly they were. Waters of the United States must meet the traditional test of navigable waters or have a continuous surface connection with such waters. Now, if they understood what the traditional test was, floats a Supreme Court opinion, I could live with that. Right? I mean, they had imagined, and part of it comes from this idea of the trees, not the forest, looking only at the Clean Water Act cases and not trying to put it in this grand historical understanding of navigable waters or waters of the United States. They somehow thought that it had to actually, the waters themselves had to be meaningfully useful for commerce or continuous surface connection with such waters. But there's no precedent, at least before Rapanos, to say that. They don't actually say that in Rapanos itself. Justice Kennedy said the regulatory authority reaches any waters with a significant nexus between regulated waters and traditional navigable waters. And of course that's, anybody's guess in any given setting. Chief Justice Roberts did not indicate his position on these issues. He sometimes counted as joining the plurality, but actually, if you read his opinion, all he says is the Corps of Engineers doesn't deserve Chevron deference. If you're not a lawyer, you don't know what that means, but I don't have time to explain it. And the dissenters said, we will defer to the Corps' interpretation of the statute, which was very broad, and it's what's still being debated today. Now, does the Constitution require some such limit? They didn't actually say that. They based their decision on a statutory interpretation of the statute. I think as an interpretation of the statute, they're flat out wrong. If you take a Federalist reading of the Constitution, then I would also say they're flat out wrong. If you want to stick with the Anti-Federalist reading, then maybe they got an argument about the Constitution, but they didn't base it on that. And of course, lower courts have divided over what this case means. Many courts have applied the significant nexus test, which you'll notice only got one vote. Now, there's a rule. There's a rule about decisions like this, which says what is the precedent when a court fractures like this, and it is the opinion that is narrowest on the facts. Makes the least sweeping conclusion, which arguably is a significant nexus test. A few courts have said, which I believe Scalia wrote that opinion, right? Continuous surface connection. Others have said, well, it'll be navigable waters in the United States under the Clean Water Act if it meets either test, significant nexus or continuous surface connection. So the lower courts are all over the place. And one judge, and a district court judge, simply said, I don't know what it means. I'm going to transfer this case to another judge and let him worry about it. and that is what the Corps was trying to deal with. Now this is, I can only throw this up real fast. I'm already out of time, right?
No, take your time. I'm not going to use all 30 minutes.
All right, bright line inclusions. Corps says people need business people making investments, Corps of Engineers, EPA, other state officials trying to adopt and apply regulations. They need some bright lines. They know it's either in or out of their jurisdiction. And so they said, all traditional navigable waters, whatever that means. Interstate waters, well, that actually would be traditional navigable waters already. Territorial seas, impoundments of these waters, a reservoir. Tributaries of these waters, and some of the debates over what does that mean? What is a tributary? And all waters adjacent to these waters. Now that takes in an awful lot of water. It doesn't quite take the isolated duck pond in a farmer's field. But it takes in an awful lot. And if it's not covered by one of these bright line rules, the Corps, at least, this is the Corps' definition for itself. This is the most recent proposal, is, well, then we have to decide on a case-by-case basis. In other words, look at the facts and try to figure out, does it or does it not have a significant nexus to navigable waters? For example, if you look at the bright line tests, they all look like, to me anyway, surface waters. Where does groundwater come in? Answer, significant nexus. If you pollute groundwater, can the Corps or the EPA regulate it? Well, the answer is, yeah, if the pollution will go into surface waters, I think that's a significant nexus. And all these terms, by the way, are undefined. Every last one of these terms are not defined in the regs. And here is an irrigation ditch. Is that waters of the United States? Is it a tributary? Is it is it self-traditional navigable waters? What if people are allowed to, I've done this when I lived in Oregon, to float, as we call it. Canoe, really, but we call it float tripping. What if we're allowed to float trip in an irrigation ditch? Does that make it navigable waters of the United States? And a lot of questions. Corps tries to solve the problem with bright line exclusions, you see. Waste treatment systems are not included. Prior converted cropland, that is wetlands that have been converted, drained and converted to crop usage before the regulation was adopted, are not included. Ditches that only drain uplands and do not have a perennial flow are not included. That's pretty narrow when you get down to it. Ditches that do not flow into a traditional navigable waterway. You see, you got a lot of ditches in the swamps of Louisiana, but they're all, almost all anyway, connected one way or another to traditional navigable waters, so they're not excluded. Artificially irrigated area. Well, you've got a rice farm. Rice is a swamp grass, so you've got to keep it flooded at least half the year. Does that make it waters of the United States? The answer is, according to this, no, because it would be dry land if they didn't irrigate it. Artificial structures like ponds or lakes constructed in dry uplands, groundwater is excluded. I don't understand that. Well, for the Corps purpose, it makes sense. For the EPA purposes, it doesn't. The Corps' obligation is to protect navigation, but the EPA has a broader responsibility, protecting waters from pollution. Gullies, rills, and non-wetland swales, whatever that means, right? But again, none of these terms are defined. And so even though the Corps says it's trying to give you bright lines so you know what's in and what's out, there's a lot of room for debate. And where does go back to my first slide, where do stormwaters fit in? That's it.
Oh, you left the mystery clicker up. Great.
Yeah.
All right. Not sure what I'm supposed to do here. Which is pretty much the lot of my life.
Press escape,
Oh, escape? Okay. Will do.
and then you can turn that off.
All right. I got to find mine wherever it happens to be.
We'll have enough people up here in a minute to make this work.
Go ahead, please. I'll just open quickly. I want to thank everyone at Tulane Law School for having me here today. This is actually the second time I've spoken here. I spoke here, I think it was two years ago, on the Virginia Uranium Project, and that was a very invigorating discussion with a number of folks. I think I recognize a few folks already from that presentation in the audience. But I do thank you all for having me here. And the purpose of my discussion today, first let me make a couple of comments. One is I thank Professor Della Pena over there. If I had him as my law school professor, I would have enjoyed law school a lot more based on what he talked about, because that was a tremendous presentation. The second thing is everything that he talked about in his presentation is exactly what I'm talking about today with regard to the National Mining Association's perspective on this rule. As a general theme, and you're not going to see this in the slides, but I'm going to tell you this now, that as an attorney representing companies in the mining industry, all we've ever really cared about is clarity in the regulations. What is expected of us under federal law, under state law, whatever it may be. Because, as my father likes to say, the best thing I like about poker is I know what hand I've been dealt. So that's what we need to understand. And as you could hear from the prior presentation, as I hope you'll see in mine, is that we don't know what hand we've been dealt here right now. There is a significant lack of clarity, not just from an attorney's perspective, with all the cases we talked about and all the, quote, bright line exclusions, which we don't really know what they mean. And then, by the way, anything else that doesn't fall under them, we'll look at it based on the facts. If you don't know that, you can't deal as a company with these things. You can't budget a process. You can't understand a permit. You can't understand what you are required to do to, for example, I mean, as you heard before, the majority of my work is under the Nuclear Regulatory Commission under the Atomic Energy Act, and I do a lot of Bureau of Land Management work. We have specific statutory missions we have to follow under those statutes. Protection of public health and safety, preventing pollution, protecting the environment. Well, if we don't know what's expected of us, there's no way that we can put an adequate proposal together to an agency. So, just a quick summary, as you can see from the slide up here. The rule was put out last year, and obviously you've heard that there are many nuances associated with it that need to be looked at, and you'll see those in the slides coming. But the most important thing to understand is that what is typical, in my opinion, of federal legislation is that with most energy policies, and again, you know, because it's not just, the mining industry is not just associated with the environment, it's associated with energy policy, is that this government fails to understand that our country is not a singular body. It is based on resource development, based on climatology, based on meteorology, based on cultural resources. We live in different sectors. So everything that you would see in the states of, say, Arizona and New Mexico are not the same thing as things we see in the states of West Virginia, Maryland, other places like that. So there is a fundamental lack of understanding on the part of the federal regulators to craft legislation that eventually becomes regulation that addresses these issues. And you'll see in the slides to come that this rule is yet another example of that. Okay, and I will tell you this, that anybody who's interested in reading the comments that were filed by the National Mining Association on this rule, I'm more than happy. I'll give you my business card and I'll email them to you as soon as I can. But just to provide you a summary, this is basically what what NMA's perspective was. We had a coalition called the Waters Advocacy Coalition that participated in the comments on this rule, the proposed rule, as well as an analysis of the final rule. And what I'm going to present to you today is the analysis of the final rule. As you can see, some of the items here, we recommended excluding on-site waters from federal jurisdiction. Yet again, one of the things people don't understand is that, like, for example, I work with mining companies in the West, like the states of Wyoming, that have on-site reservoirs that are not what you would typically call a reservoir. They are a reservoir and they serve as a reservoir. There is more of a site-specific analysis than anything else. And again, one of the other things in the mining industry you deal with is maintenance of waste materials. And as you probably know, in many mining operations, there are evaporation ponds, storage ponds. I know that one of the major groups I work with are what are called in situ recovery uranium facilities. They have evaporation ponds, surge ponds, because the water that is in the ore body where they remove uranium from has, let's just say, elevated radiological material in it. I'll actually tell you this quick little story. I was privileged to go to a meeting with the Region 9 EPA administrator many years ago, and we had a project in New Mexico where we were trying to take samples of what the radiological content of the water was in the ore body. And my law partner had said to the administrator, didn't the agency propose a 300 picocuries per liter limit of radon in drinking water for a rule? Now, that rule was never finalized, but it was proposed. And she said, yes, that's correct. And I looked at my client and I said, can you tell them what the radon content is in the water in the ore body? He said, 4 million picocuries per liter. She almost fell out of her chair. Because, if uranium's there, there's going to be other stuff there. So what I'm saying is what needs to be understood is, if a navigable water or water of the United States is going to be considered under these definitions, whether it be a bright line test or a case-by-case test, you have to take these circumstances into account. All right, here are the these separate categories of analysis that we did on the final rule, and we'll go through each of the steps, each of the analyses step by step here. But you'll see it's what is actually called categorically jurisdictional under the Clean Water Act, exclusions, on-site waters, and you've heard some of this already. And then the other key concepts are actually neat little nuances that these are the things that no one focuses on. Is that you look at the big ones, the big couple things, but you don't look at those smaller items that are very important. Okay, on-site waters. Now, when I say positives, I mean it's what the mining industry looked as something that lends clarity to what they have to do in permit applications. First, you have the exclusion for waste treatment systems. We already heard about this. Treatment ponds or lagoons maintained. Categorical exclusion for artificial ponds used in non-agricultural settings like settling basins. Exclusions for stormwater control features. We heard this in the previous presentation. Stormwater is a big issue because, especially in arid regions of this country, stormwater and NPDES permits are a big deal. Where I live in Virginia, it's not that big of a deal. But in states like Wyoming and Colorado and Utah, New Mexico, they are a big deal. So that's something that, again, has not been properly addressed. And then excuse me, wastewater recycling systems, and as you can see, this is a long sub-bullet. And that's, again, yet another problem. There are so many details and so many nuances associated with these things, it's hard to properly understand what you're dealing with at a given time. Now, here are some of the problems. Most exclusions apply only to features constructed in dry land. Well, I mean, that means something to the folks down here because, you need to understand what you're dealing with. Ditch exclusions, we heard about this previously. Ditches are a huge issue. And really, from my reading of the statute and all the regulatory history and the rulemaking materials, I still don't know what the heck a ditch is. I mean, it's a very difficult concept to get your arms around. Now, here, the third sub-bullet is something I'd like to focus on for anybody in this room who is attending law school here. One of your biggest allies and potentially one of your biggest enemies in a rulemaking process is the preamble language to a rule. It can be your best friend. It can say, this is what, section XYZ sub B1 whatever means. But then on the other hand, it can lend complete confusion to you. Well, that's one of the problems we have here with on-site waters. The preamble language mentions things, but it doesn't clarify anything. Dry land term, again, unclear. There is no clear application of that term in the rule. Tributaries and ephemeral features, we talked about this in the previous presentation, but I'll just give you a little bit more detail. Erosional features, again, this is another example of something that is not addressed based on the climate and the topography of different parts of this country. Arid regions have ephemeral features all over the place. And but they're not properly categorized. They're not classified appropriately. And when a company, any company, tries to go in and mine responsibly, which is what I advocate, they need to know what this means. Because if they need to protect it, if they need to put safeguards in place, they need to know what they have to do. And many of the problems we have associated with these issues is, for example, let me give you an example. Other than the Nuclear Regulatory Commission, which I deal with primarily, the two major agencies I deal with, the Bureau of Land Management and the Environmental Protection Agency, okay? They both have headquarters offices in Washington, D.C., right down the street from where I have my office. But they also have regional offices. And the regional offices are empowered to discuss and implement what these rules are. You don't always get a consistent interpretation. And that's the problem. Is that if you have something that is within Region 8 jurisdiction, which is South Dakota, Wyoming, Colorado, and then you have something in Region 6, which is more like Texas and other areas down near here, you don't necessarily get the same interpretations. And if you don't get the same interpretations, there's no clarity and no consistency in regulatory authority. That's a problem. And again, here's another one of those long sub-bullets, the second sub-bullet. Again, you have to sit there and run through all these steps to understand exactly what these terms mean. And as our professor here told us earlier, you don't have a clear definition. It's very difficult to apply these things. And then when you hang your hat on categorical exclusions and you hang your hat on items that are bright line tests, but then you say, by the way, we're going to do a case-by-case analysis of these other things, you don't know what you're dealing with. Okay, here are some negatives again. Ordinary high water mark. That is a term of art under the Clean Water Act for this issue. That term just went from something that we sort of understood to something we don't understand at all. We have no idea. It could do one of two things. It could exclude a ton of things, a ton of features from jurisdiction, or it could bring everything into the jurisdiction. We don't know the answer to that. And by the way, one of the worst items that you deal with as a person like me who works in this industry is not how much do I have to spend to get a permit. It's, do I need one? Because what happens when you go forward to your operation, you say, I didn't have a problem here, and they say, no, 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 you do. That's a problem. If you don't know you need a permit, it's not even an issue of, okay, they have jurisdiction now, file the form and, you know, put it in the application, here are the safeguards I'm going to put in. What if you don't know you need a permit? That's a problem. Okay, there we go. Sorry about that. Here are the adjacent waters issue. This is always a fun one. Look at that definition. I mean, can you digest that in a minute? I mean, seriously? It's very difficult. You have all kinds of different items here. And the question is, for example, if I have a site in Wyoming where I'm trying to engage in a mining operation, whatever it may be, and you have something that looks like a river stream bed, but it's never flooded, ever. Maybe once every 12 years or something like that. What's my job? What's my responsibility for this? I don't know the answer to that. Because, again, don't forget, EPA has state delegated authority under the variety of statutes that they have. So if you delegate it to the states, they implement. So the question is, are you dealing with EPA headquarters and their region offices, or are you dealing with the state? And if you're dealing with one or the other, what's their interpretation of this rule? You are throwing too many cooks into the kitchen. Again, here, look at the third sub-bullet. Again, what's the word? Subjective. Subjective interpretations are the mother of all, insert expletive here. You don't want that. You want, as we talked about in the previous presentation, you want something that's clear in terms of this is in, this is out. That's it. And if you know it's in, you know you have to deal with it. Like, and another thing I do, one of the other things I do in my legal practice is due diligence evaluations for projects, okay? One of the critical aspects of it is how much is it going to cost to develop the resource? Well, if you have a number of line items that have nothing but a question mark next to them, that's a pretty bad due diligence evaluation because you don't know what it costs. So is it, I have to comply with the statute. That's the end-all, be-all of the game. I have to comply. What's it going to cost? And if it costs too much, I'm not going to develop the resource. Okay, here are the other key items. Significant nexus, we talked about that earlier. This is the opportunity for jurists to keep their jobs until they retire, which is, it's wide open. I mean, you can really sit there and say, I mean, look at that definition. When any single function or combination of functions performed by the water, I'm not even going to finish that. How complicated is that? I mean, it's really one of those things where it is an exercise in futility as far as I'm concerned. But you can, when you read it, you can understand where they were coming from, but they sure as heck didn't write it appropriately. And then again, certain aquatic functions, that is a list in and of itself that you have to go through in terms of making a determination. Case-by-case analysis on waters. There are a couple examples of additional waters that would likely be jurisdictional, prairie potholes. There's a longer list. I just put 3 up for example, but there's a much longer list. And again, if anybody wants to read the comments, you'll see from NMA, you'll see what they are. But again, here it is, right there, case by case. That's the problem. That is where the uncertainty lies. And the most important thing to understand is sometimes it's better to err on the side of caution and just say, look, I'm going to just assume this thing is going to be within the jurisdiction of the Clean Water Act and I'm going to deal with it appropriately. Because at the end of the day, the more you fight something like this, the worse it gets. So just say, I'm going to do what's necessary under the statute. I'll get it eventually. There we go. Grandfathering. Here's an important one. For all you law students out there, this could be your best friend when you're doing litigation. Grandfathering under this rule. Pre-existing jurisdictional determinations are grandfathered. They are not subject to reopening. There's actually a legal case at the Nuclear Regulatory Commission that has a funny name. It's called the 8 Old Rec Plans decision, reclamation plans, meaning rec, that the 5 commissioners told the NRC staff that you are not to go back in and reopen decommissioning plans that were previously approved until you can demonstrate an imminent hazard. And that's a very high standard. Well, that's not here. Here, it's done. The determination was made, it's done. Associated with issued permits and authorizations, as all of you may know, with these agencies, any agency, permits have a shelf life. At NRC, the permits are 10 years old. For nuclear reactors, they're 20 years old. For different BLMs, plan of operations or things like that, they vary in time frames. Any determination made under an existing permit is valid until the permit is up for renewal. So if the permit's up for renewal, then you have to go under the new rule. Pending determinations, they're not covered. So if you put in a permit application a year before the final rule came out, and the final rule came out and you didn't have a decision, you're subject to the new rule. That's the end of that game. Groundwater, the last hot button issue. Groundwater is a very touchy issue for a lot of people, out west especially, because as you are, I'm sure you're all aware, groundwater is a primary source of drinking water for states like, as I mentioned before, Wyoming, Colorado, New Mexico, Utah, Arizona. And one thing I will mention based on the last presentation is that the reason we don't have as much focus on groundwater for this is because of the Safe Drinking Water Act that is specifically designed to protect underground sources of drinking water, or USDWs. They are geared toward public water systems. For example, if you have a municipality that gets its drinking water from groundwater, you are covered by the Safe Drinking Water Act so long as you have in excess of a certain number of users. However, if you're a rancher in the middle of Wyoming and you have a well on your site and you're using that groundwater for drinking water, the Safe Drinking Water Act does not cover you. The federal authority doesn't cover because it's less than what's required for a public water system. So that's, again, the final rule maintained the exclusion of groundwater, and that's part of the reason, because I think that the Safe Drinking Water Act has a large amount of authority, not just covered by their aquifer exemption authority that I deal with on a daily basis, but also they have underground injection control permits that deal with different classes of mining, whether it be oil and gas or the kinds of things I deal with uranium or other types of mineral recovery. Very strict, non-subjective limits. They're all objective. They say if you have this much TDS and it's for mineral recovery, you can have an exemption. But it's only a portion. You never exempt an entire aquifer because aquifers are gigantic. I mean, they're regional. They're not state-based, they're not county-based. They're regional. There is one question, however, under the rule, whether groundwater can act as a point source or a hydrologic connection necessitating an NPDES permit. Again, that is an issue that has yet to be vetted. And we have analyzed this to the nth degree, and we still don't have an answer. I mean, I like to say they had their best lawyer on it, but that was me, and I'm not sure that's true. But I don't have an answer for you, because I don't know. I don't know what the answer is. So this really, I've been associated in my 15 years in the legal field with many proposed and final rules. And I've seen many that have stood on their own, and I've seen many that have required, for lack of a better legal term, tweaking. I think this one's going to need it. And I'm waiting for it to happen. So we will see. And I thank you for your time and answer the questions.
While you think of some questions that we have time left, I want to just ask a quick question to Christopher Pugsley, and that is, the idea of certainty, I think, is really important for the regulated community, right, and for companies. And I'm wondering, it seems to me that if there is an absence of regulation of some of these waters, then the alternative is not no regulation, but individual states having their own systems to regulate arroyos and cataracts, and so you'd have California with the system, and Nevada, and New Mexico, and so on. Would it be easier or harder for the companies you represent to have one federal rule, as difficult as it might be on the edges to figure out, or would your clients rather have many different state rules on top of that?
If you ask me whether I would rather have the rule as it is currently constituted federal or individual state programs, I take the latter. And the reason I say that is because there would be clarity that if someone wanted to go into a particular state and develop a project, they'd know what they're dealing with. The problem is that when you have to actually enlist a team of lawyers to understand what your permit application is going to look like, that makes no sense. And frankly, as far as I'm concerned, responsible regulation requires clarity. And what I always tell my clients is err on the side of caution, is that make sure that everything is taken care of. So I would go for the latter.
Okay, sir.
Yeah, I guess I find your presentation a little puzzling, because on the one hand you say you want clarity, and on the other hand then you say, well, sometimes they get it wrong, and then, then we have a problem if it's inconsistent, and then we have these long definitions which are clearly designed to provide clarity, but then you say, oh, the definitions are too long. I don't quite understand how you can have a short, pithy definition that then provides the clarity that you need. And maybe reinforcing that, so the National Mining Association's president said, we remain deeply concerned that the promised clarity from this rule comes at the steep price of more federal interference with state, local and private land use decisions. So do you disagree with that statement?
Oh, I can't speak for the president of NMA, but I can say that I think that there are the items that I talked about today are items that could use more clarity, and they could also use more evaluation. I think that there's I personally, and this is my personal opinion, that I think that there are aspects, different parts of this country, where they need to be looked at with more of a fine-tooth comb than this. I agree with NMA's president that more federal interference is not appropriate. But at the same time, I also believe that on a general basis, not just with this, but in any legal discussion I have with anyone, that clarity is not your enemy, it's your friend.
Right.
And that you need to have as much as you can. Now, again, my comments were merely based on legal analysis of the rule. So I agree with you that you want to have definitions that can lend some clarity, and clearly these things are complicated. And sometimes they necessitate longer definitions and longer explanations. In this particular instance, I think that the examples I talked about were where longer definitions did not help.
I mean, isn't it?
I want to bring in some others just because we have some limited time. Go ahead, ma'am.
Maybe the wrong kind of question, but given the new SLOSH maps, the storm surge maximum maps for this region that take storm surge waters all the way to I-12 or Baton Rouge and Cat 3, how does that change in terms of, and how much does that affect how we view water as part of the Gulf or part of the river moving as a, part of the river system? And how much does that research that NOAA has done affected or not affected what you all are doing?
Well, first of all, I think that's a fantastic question. Secondly, I don't have a clear answer for you. I believe that one of the things that we have had trouble grappling with is the connection between adjacent waters and other identified waters of the U.S. or navigable waters and how that meets a particular test. But truthfully, I think your question is 100% valid, and I think it needs to be answered. But I don't have an answer for you.
Ma'am.
That would certainly include everything to I-12 as water, no matter what.
It depends on how they would implement the test.
Yeah.
Yeah, I think your question is very fair. Very fair.
Ma'am.
I was curious, it's my understanding the rules stayed,
You want to speak to that?
or what everybody's doing pending that.
Well, it's before the courts. I think it was state.
It's injunction.
The Clean Power Plan was stayed.
The Clean Power Plan.
No, but isn't there an
That's by the Supreme
injunction?
Court, but I believe there was an injunction issued by a lower court, staying intentionally.
We're like 16 states, and so EPA, for all intents and
Not state
purposes, yeah, we're staying the role nationally because, but it's not staying in the same sense that the Clean Power Plan
No.
stays.
Just so we understand, just
Because this is the front room.
because I'm thankful for this. So you're saying that the EPA has voluntarily put a block on implementing its rule until it's
Yes.
It's barred in, she said, in 15 states.
in 15 states.
So they voluntarily did it in another 35.
Right, right. Okay. Sir, in the back.
Yeah, I mean, you like listed all these terms, and I mean, as someone who's not a lawyer but a biologist, and in terms of larger terms for experts, it makes sense. For instance, the hydrologist, how much do you want to define in the rule, and how much do you want to just have like experts tell you, and submit to the core of the jurisdictional determination, and have things just be determined by experts on the side? Wouldn't that resolve like a lot of the
Well, let me just sharpen that and get that, because the language that was posted up here that seemed kind of long and convoluted in the rule was actually, if I got it right, verbatim language taken from Senator Kennedy, or Justice Kennedy's decision. And I think one of the things that Kennedy seemed to want to do was make sure that it functionally and biologically was correct. But that seems to conflict with this idea, which is also a very strong value, of wanting some certainty and predictability. So how do you think that that should be balanced?
Okay, very good question, and my answer to that would be, to the extent that you can obtain regulatory certainty, where the experts don't have to get into a battle of the experts, which frequently happens in litigation contexts, as well as in, and frankly, it's not even in litigation. It's in the experts at a particular agency where you're applying for a permit versus the experts who are your experts submitting the application. To the extent you can get the regulatory certainty in advance, that is to your advantage. Now, do I believe you can ever have 100% certainty? No, you can't. It's impossible. I mean, we're a society subject to the rule of law, which means confusion at some points. But yeah, I agree with you that experts need to be put into this. But my question would be, I've had experience in the last decade with rules that have been developed that are claimed to be supported by experts where it made no sense based on what I've done. And I don't have a science background. The only science I ever studied was political science. But I will tell you this, that I know enough about hydrology and geology to know that some of the things that have been put out make no sense whatsoever. Some have gone through, some have not. However, to have a rule that gives you certainty that is based in sound science would be my ideal objective.
Sure. Let me
Oh, yeah, go ahead, Joe.
throw something in. See, this rule, or the statutory language on which it's based, is a jurisdictional rule. It's simply saying whether Corps of Engineers, EPA, some other government agency has authority to decide whether a permit or license or whatever is required, and then to decide whether to issue or deny that permit or license. It seems to me that the scientific input, this is where you want clarity. We want a clear jurisdictional rule. Either the permit is required or it isn't. Can't have 100% clarity. We'd probably get closer to it than we are now. Where the scientific input, that should be somewhat germane to the jurisdictional rule, but where really it should become important is whether to deny or issue or condition the permit. That's where you need to have the good, most need at least, to have the good science.
I think that, let me say one more thing. The word, I think you hit it right on the head, condition the permit. Because one of the things that they joke about at the Nuclear Regulatory Commission is, because it's an independent regulatory agency and it's, quote, reactive, is that they don't promote nuclear power. You have to go and apply for a license. They say, you propose, we dispose. That's pretty much how it works. So they have, under the statute, they have only 3 things they can do. Issue the license as you ask for it, deny it, or issue with conditions. The conditional thing is the most important thing, because that's where all of these nuances come in. That you come in and say, I want to do X. Well, they say to you, you can do X, but we're going to put Y and Z on it, and then that's fine under the jurisdictional statute. That's
Okay,
what I think is.
I've got 2 minutes left, and I made 2 promises, and we're going to keep them. So I'm going to ask you to ask a question very short, and I'm going to ask you the same thing, and then we'll let the 2.
It's all right, I'll give my time over to this gentleman because the professor is good enough to prepare.
Oh, excellent. Okay. Boy, sometimes that really works. Okay, go ahead.
I promise I'll keep mine very short. There's a lot of talk about the lack of clarity there. It's very hard to write laws and apply them nationwide in these environmental contexts and have them be clear. So now, I understand you can poke at the lack of clarity, either or both of y'all, but how would you prefer to define it, or would you prefer to tear up the rule and start anew? And but if so, how would you do that?
You want to go first?
I would take the traditional navigable waters of the United States as the limit of the Clean Water Act jurisdiction, which means if it can float a Supreme Court opinion, it's subject to EPA and Corps of Engineers jurisdiction.
Very clear. not going to talk outside.
You got something better than that?
I'm working on it. I will, and let me preface this by saying this is my personal opinion. I'm a fan of the 10th Amendment. I believe any powers not enumerated to the federal government belong to the several states. I think it should be under state jurisdiction. That's my opinion.
Well, you heard it here. Okay, thank you very much.